Well, good afternoon, everyone, and welcome to our webinar on staying away from employment tribunals, something that I suspect is close to the hearts of an awful lot of employers. So, the reason for this webinar and this topic this month, well, the decision of the Supreme Court in July 2017 that the high level of fees in the employment tribunal is unlawful means that we go back to where we were before. A situation where most claimants can lodge a claim with the employment tribunal without any financial commitment on their part. So the question that a lot of employers are asking themselves now is this going to result in a return to the previous high level of claims? As usual, in our webinars, we look at the background, give you some information about the law, but we also aim to provide some practical pointers and some action points to help protect your business and keep you away from tribunals if possible. Before we launch in, and for any of you who may not have attended any of our previous webinars, we'd just like to introduce ourselves. So my name is Alison Blackhurst. I'm the HR Knowledge Manager at HR Solutions, and I will be leading today's session. And I'm joined by my colleague, Sue Watson, our HR Operations Manager. Hi, Sue.
Hi Alison, and hi everybody else. I'm here to keep an eye on the questions and chat panel, so if any of you do have any questions about the webinar that we're about to deliver, and also any problems technically that I might be able to help with, then do send through your messages or your chat through on the admin panel that you have. We are recording today's session, so it will be available afterwards. If you would like to receive the link to the recording, then please let us know. We will also can make available a PDF copy of the PowerPoint presentation that we're delivering. If you'd like that, then email us again and we can send them through to you. Thank you very much.
So everything I say can be used against me in evidence. Oh dear. Okay. So for those of you that may not have faced an employment tribunal before, just a little bit of introduction first of all. It's not just about unfair dismissal claims. Employment tribunals can deal with around 70 different types of claim. Obviously including unfair dismissal, but also equal pay claims, claims for unauthorized deductions from pay, breach of contract claims raised on or after the termination of employment up to 25,000, and claims under the working time regulations. And they also hear discrimination claims. So a wide range of claims. And most of you will be aware of the recent decision of the Supreme Court. And basically, what they decided was that the introduction of the high-level fees in the employment tribunal was unlawful. Now, the fees were introduced just over 4 years ago. And what they aimed to do was to transfer part of the running costs of the tribunals to users and to discourage weak claims and to encourage the use of alternative methods of dispute resolution. What happened, the result, was a huge, over 70% reduction in the number of claims. Now, the fees had a mixed approval rating. Some employers were very strongly in favour of them, and they felt that the pendulum had swung just too far in favour of employees, and that having fees would deter employees from making claims that were without merit, but they were making them just in the hope of getting some sort of payout. On the other hand, we have the unions who are violently opposed to the fees on the grounds that they blocked access to justice, particularly among some of the most vulnerable people in society. So Unison, the union, brought a challenge to the fees, and it took them around 4 years to work its way through the court system. But at the end of July, the Supreme Court said that the fees order is unlawful. And this was on 2 grounds. Firstly, because the level of the fees was too high, it was found to prevent access to justice. And the fees were over £1,000 to bring a discrimination or an unfair dismissal claim. So the Supreme Court said that they weren't affordable by those on low to middle incomes, and they also limited the ability to enforce claims which were based on EU law, which is actually unlawful in itself under EU law. And secondly, the fees were ruled to be indirectly discriminatory against women. The Employment Tribunal Service had previously said that they would refund any fees paid over the last 4 years if the fees order was declared unlawful. So they're currently deciding how to set about this whilst ensuring that they do actually only make refunds to those who are entitled to them, because a lot of successful claimants had their fees reimbursed by the employer as part of the award. So more details of the refund scheme are expected shortly, and they're also considering what to do about claims that were dismissed or struck out for the non-payment of fees. And in the meantime, the stay that was put on all claims and applications arising from the Supreme Court's decision was lifted. And the first case brought by an applicant who didn't bring her case because of the fees has been allowed to proceed. And it concerns a female worker, Miss Darmy, who applied for help with the fees but was refused, and so she didn't file her discrimination claim. She will now lodge her claim against Tesco for disability and age discrimination. So things have changed. Will they change again? Will the government try to reintroduce the fees, but at a lower level? Because you do suspect that if the fees had been set at a much lower level, then the fees order might not have been ruled unlawful in the first place. Now, if the government did this via an act of parliament, it wouldn't be so easy to challenge, but it does seem unlikely. First of all, if the Conservatives had had a majority, then it would have been a strong probability. But the government's now bogged down with Brexit, and the Minister for State and Courts and Justice hasn't given any indication that there are any plans to reintroduce fees. You might also remember that as part of their election manifestos, both the Labour Party and the Lib Dems had pledged to abolish the fees. So certainly the government wouldn't get support from them. So the overall level of support for fees in tribunals suggests that any reintroduction of fees does seem unlikely. So are we going to go back up to the previous high level of claims that were brought previously? And will there be an immediate surge due to people making retrospective claims because they didn't bring their claims in the last 4 years because of the fees? Well, it's an interesting question, and obviously we don't know the answer to that, but being optimistic about this, well, maybe we won't go back quite as far as the previous levels, mainly because of the Acas conciliation scheme, which was introduced around at the same time as the fees. And that has proved to be an effective and a cheap way of settling the smaller and more straightforward claims. And Acas's involvement does tend to encourage a more realistic approach from both employees and employers. So given that an employee still has to approach Acas before they lodge a claim, they don't have to participate in the Acas early conciliation, but they do have to have dealings with them beforehand. This may well encourage the greater use of the Acas conciliation scheme, and therefore it may keep a lid on the number of claims. And employers as well might be more prepared to settle early on in the process, because there's going to be no point in them sitting on the fence and holding fire and waiting to see if the employee will be prepared to pay to pursue a claim. In addition to Acas, mediation is also proving increasingly popular amongst those employers that have access to trained mediators. So in reality, we might not go back to the situation as it was 4 years ago, but what is likely is that we will probably see an increase in the following sorts of claims. First of all, claims from gig economy workers, because there have been lots of these. And these are mainly from people who have been categorized as self-employed, but who are actually undertaking the work personally and therefore should have been categorized as workers and should be given holiday pay and at least the national minimum wage. So we're talking about lots of small value claims here, but these do add up. Now, a case that is going to the Supreme Court is the one of Pimlico Plumbers that you might have been following, and other names in the news on this topic are Uber and City Sprint. And the appeals against the rulings in the latter two cases are likely to go to the Employment Appeal Tribunal shortly. Now, if either of these appeals are unsuccessful, then we can expect a lot more such claims, especially given the high level of media coverage of this topic. We're also possibly likely to see a lot more discrimination and equal pay claims. Firstly, because the Supreme Court had acknowledged that the introductions of fees was a particular deterrent to women, But also the BBC had so much high-level media coverage of its pay figures that has again made this a highly topical issue, in addition to the fact that employers are now starting to publish their figures of their gender pay gap. So we do expect to see more claims there. And we may well see more claims for holiday pay. We've now come to the end of the holiday season and the children are all back at school, but for those who earn regular overtime or commission and who only received their basic pay rather than their normal pay when they went on holiday, those people have a 3-month window in which to consider whether to bring a claim or not. And a lot of employers had decided to sit on the fence and adopt a wait-and-see attitude to holiday pay calculations. So given that it's now clear that holiday pay should include normal regular overtime and commission payments, there could well be lots of small value claims on that topic. And finally, the minimum wage. Again, we could be talking about a lot of low value claims here, but there have been a number of tricky areas. For example, sleep-ins, payment to those on call, and even the largest employers have fallen foul of the minimum wage rules. So again, small value claims, but ones which do add up over time, and especially where there are multiple workers involved. Now, why do smaller employers in particular fear employment tribunals? I mean, we have some clients that would actually do anything rather than end up in tribunal. They really don't like the idea. Well, tribunals were originally set up to be an informal means of resolution, but over the years, the process, the 3-person panel for discrimination claims, the swearing of the oaths, the calling of witnesses, etc., and the sheer amount of paperwork involved in it all can be very, very daunting. Going to a tribunal is not a comfortable experience for most people. You can expect your business and its procedures to be scrutinized. It can create a lot of stress to those concerned, and it can also be very costly, not just in terms of any awards that are made to the employees or ex-employees, but because of the sheer amount of time spent preparing the case and gathering the documents and worrying and diverted effort from other important business issues. Management time, there can be quite a lot of people involved, particularly if you're calling lots of witnesses, and their time is spent preparing for and attending the tribunal. And then on top of all of that, you have the costs of bad publicity and lower morale. And tribunal rulings and rulings from the Employment Appeal Tribunal ruling are now also available online. So what this means is that your investors or your employees, unions, customers, clients, and your competitors can access and read the full judgment of any case you are involved in. So there's no option of concealing some less than perfect processes. So you can understand why a lot of employers really would like to stay away from employment tribunals. And it therefore makes sense to take steps to minimize the risk of ending up in tribunal and to ensure that issues are handled properly. Now, this can be particularly difficult for smaller employers if they don't have a dedicated HR resource, unless they have outsourced advisors such as ourselves to guide them through the processes. Clearly, no employer can ever guarantee that they won't end up in tribunal at some stage, but if you follow the steps that we outline below, this will minimize the risk. So the first part of your avoidance plan starts before you actually appoint any new employee, because candidates can make a claim to an employment tribunal if they consider that unlawful discrimination has taken place. So a bit of preparation before you actually start to recruit will really pay off. And what that involves is, first of all, making sure that your recruitment advertising isn't discriminatory in any way, either directly or indirectly. Now, the old-fashioned job titles of things like tea lady and dustbin man are probably long gone, but it's not just gender issues, it's all of the protected characteristics, so race, sex, disability, pregnancy, maternity, religion or belief, gender reassignment, etc. So check your adverts. Think about the role that you're recruiting to. Do you have comprehensive job descriptions and person specifications, and are they up to date? Are you absolutely clear about what the new recruit is going to do Or are there any areas there that could benefit from further clarity? Because if you tie all of your questions and all of your activities closely to the role that you're recruiting to, the chances of you straying into inadvertent discrimination are much, much lower. So when you're selecting, are you using the correct criteria? Are you carrying out the process objectively, and have you chosen the right person for the job? If you use your person specification to clearly define the skills and the experience that you need, and if you also try to build in some tests or assessments that enable your candidates to demonstrate their skills, and which you can score or rate in a more factual manner, rather than just relying on the interview, then you are less likely to face a discrimination claim. So the more objective your process, and the more your candidates can see it to be objective and fair, and the less it relies on personal preference, the less likely you are to face a claim. Now, if your managers haven't been trained in interview skills, then that can be an area where bias plays a large role, both unconsciously and consciously. So either train your managers or perhaps involve more than one person in your recruitment process. Think about the interview questions and tie them to the role. You should not be asking women if they're going to plan to have children. You shouldn't be asking older candidates when they're planning to retire. Those are really, really obvious questions. But equally, we shouldn't be asking people about their religious beliefs or their caring responsibilities unless there's a genuine occupational requirement which is related to that particular job. We could go on because we've got lots of examples of these sort of things over the years. You also shouldn't be asking questions relating to health or medical conditions before an offer is made or accepted, unless you have a role that does require certain physical abilities, in which case it's perfectly acceptable to spell out what they are, for example, the ability to lift heavy goods in the warehouse, and it's also acceptable to ask the candidates if they are able to fulfill those requirements, but that's as far as it goes. Do keep good, clear interview notes which match your candidates' answers and performance against your criteria, i.e. your essential and your desirable criteria. And do keep them for 6 months, as they could be your defence against a claim, because candidates who are not selected may well make a claim if they feel they've been discriminated against. And do resist the temptation to just choose someone who is the best of a bad bunch but not really a good match, because that could give you problems in the future. If they're not matched to the role now, are they realistically going to be able to fulfill your requirements? There is a huge temptation to fill a vacancy, but taking the extra time now can save you time and cost in the long run, because recruiting an unsatisfactory person means that you're going to be involved in coaching and training, performance management, and worst case scenario, having to dismiss and start all over again anyway. So what we're trying to do here really is to get things right first time to avoid any future claims for unfair dismissal or discrimination. Given my previous comment about claims from gig economy workers, if you're making offers of work, do ensure that you categorise the working arrangement properly. So, is this person a worker, i.e. a self-employed person that you're offering work to, but they are required to undertake the work personally, and therefore they have limited employment rights, but they are still entitled to paid holiday and to receive the minimum wage? Or are we looking at full employees with full employment rights? So how regularly will these people be working for you? Who has control over their activities? What degree of freedom do they have? If you're looking at a self-employed arrangement, then do check that it's genuinely self-employment, and that if the person is required to undertake the work personally, that you do give them holiday pay. Now, if you are making a written offer, whether this is ongoing employment, a 0 hours contract, or just a casual working arrangement, make sure it's unambiguous and it also offers you the flexibility that you may need going forwards. We're looking at setting realistic expectations here and no false promises. Then you don't get the disappointment and you don't get angry employees. If you're offering fixed hours of employment, clearly you are taking on a bigger liability. So consider not only what do you need now, but also what flexibility you might need in the future. So are the hours of work flexible at all? And if so, what's acceptable? Do you need a clause that enables you to change someone's hours or to amend your shift patterns, for example? Is the location fixed, or do you actually require this person to be able to work from more than one site, or possibly to work from a different site in the future? If you think you might need to relocate either to smaller or bigger premises, then it's worth building in a clause that enables you to enforce that without there being any breach of contract. Do you need some flexibility regarding the role so that you can swap your employees between tasks and departments, or even between associated businesses if you have a group structure? And does your contract give you the right to change the job description, the hours of work, the working patterns, the date and method of payment, etc.? Does it allow you to make reasonable deductions from pay, bearing in mind the need to pay the minimum wage at all times? Might you need a layoff or a short-time working clause? All of these things that give you a lot more flexibility are sensible to include in the contract up front, because it is much harder to negotiate changes later on. Changing people's contracts without their agreement is fraught with risk, and the process of giving notice to dismiss for some other substantial reason and then offering re-employment on different terms is not one that usually results in happy employees. So it is worth trying to get this right beforehand. And it's also worth considering some checks to protect yourself as well. Not only checking the right to work in the UK, but also taking up references and checking qualifications and driving licenses, because it is much less risky to withdraw an offer of employment for an unacceptable appointee, or else to dismiss them at the early stages in the relationship than it is later on. Should you have probationary periods? Well, there is no legal requirement to have these, but they do make sense. We would advise all of our clients to have sensible probationary periods, and depending on the complexity of the role, typically we're looking at 3 or 6 months. During this time, you might wish to specify a shorter notice period, and also to confirm that your full disciplinary procedure will not apply. Equally, you might want to disapply your disciplinary procedure for the first 2 years of employment, that being the period of time before an employee can bring a claim of unfair dismissal, and you would have to follow the Acas procedures. Ensure that you give regular and proper feedback during the probationary period, because most employees will listen at this stage. They are far more receptive to guidance about what you want, and they will do their best in a probationary period to adapt to the style and the culture that you want. It's much, much harder to change people who have always done it in a particular way. Monitor the period, meet with the employee before the end date, and if you have any doubts at all, then extend the probationary period and confirm all of this in writing. But don't let the date just pass and hope you can pick up on it later, because once the end date has passed, you can't reintroduce a probationary period. Now, you may well set new targets, put support mechanisms in place, provide lots of training, but it does happen that there is no improvement in performance, and that from time to time you might end up concluding that things are just not going to work out, and you do need to consider dismissal. We would advise, even in these cases, that you do still follow a fair dismissal procedure. The employee might not have the required service to bring an unfair dismissal claim, but they still could bring a tribunal claim on other grounds, for example, discrimination or whistleblowing. So we would therefore still strongly recommend an end of probation review meeting before you dismiss any employee, because that gives you the chance to demonstrate and to document clearly that you've acted fairly. And it also enables you to disprove any other allegations that an employee may later make. They don't need any length of service to bring a discrimination claim. If you haven't appropriate documentation that shows where the employee failed in the job and that proves that you had proper discussions about this, then it is harder to convince a tribunal that you dismissed for performance. And in the absence of any genuine recorded instances of unsatisfactory conduct or behaviour or work, it is easy for the tribunal to infer that discrimination may be at the root of this. So cover your back here and ensure that you do have the appropriate documentation. That is not only likely to deter a claim because an employee will feel that they've been treated fairly, but also if they take that paperwork down to an advisor or a solicitor, they can see that you followed a fair procedure as well, and that your chances of being able to defend a claim are so much higher. Now, policies and procedures may sound very, very boring, but they are essential in terms of avoiding tribunals. They are there to protect you, to help get everyone working to the same standards and to ensure consistency of treatment. So they are important. So do take a look at your policies and rules as part of your risk avoidance strategy. Yeah? We would recommend that you look at these annually and also whenever there are any significant changes in legislation, and make sure that they are sensible documents and that they do work for you. Then monitor them and make sure that everybody follows them, because it is absolutely no use having the most fantastic written policies if your custom and practice is actually completely different and you turned a blind eye to things. Yeah. Consistency is key when it comes to tribunals. So having employees who regularly report late for work or who take high levels of sickness and then taking action against one person in one department for that is a clear risk of a discrimination claim. We would advise that any policies that you might want to change in the future are clearly stipulated to be non-contractual. Then you avoid a breach of contract claim if you don't follow them, and it makes it much easier to update them. And yes, have the most wonderful policies in the world, ensure they're robust and they're thorough and they're easy to understand, but the key thing is also to ensure that they're communicated effectively, because your employees can't be expected to follow rules that they don't know about. So provide them with policies and procedures, everything that they need to clarify their role and your rules. And make sure that it's not just employees and managers, but also that anybody else who works for you is informed of your policies and understands them. Particularly your equal opportunity and your bullying and harassment policies. IT is also another area where there can be huge risk here, because it's not just what you do as an employer, but your business can be liable for the actions of people who work for you or on your behalf. Now, Barclays Bank found that out to its cost very, very recently with relation to a doctor who was undertaking pre-appointment medical checks on a very large number of candidates. So do take steps to minimize the risk of any behavior that could result in a claim against you, whether it be on the part of the business, your managers, your staff, or anybody else that's working on your behalf. Now, lots of tribunals are lost for the simple reason that a fair dismissal procedure hasn't been followed, or because the decision wasn't actually reasonable in the circumstances. But it's not only about defending yourself if you end up in tribunal. This webinar is about avoiding tribunals, and where a fair procedure has been followed or a reasonable decision has been made, then it's going to be much less likely that employees will attempt to bring a claim in the first place. So have a look at your disciplinary procedure and ensure that it's up to date, and in particular that the list of behaviours which constitute gross misconduct do properly reflect your particular environment. The disciplinary process itself hasn't actually really changed much over the years, but the sorts of offences that employees tend to commit has done. So particularly the use of social media, what is acceptable dress codes, discrimination issues, the use of mobile phones in the workplace, data protection issues. Your rules on all of these should be clear and up to date if you are to take action against anybody for breaking them. Ensure that all of your supervisors and managers are thoroughly trained to follow the disciplinary procedure to the letter, and don't be tempted to cut corners. Whilst those with less than 2 years service can't bring an unfair dismissal claim, they might try a whistleblowing or a discrimination claim instead. So you do want to have the right documentation that demonstrates a fair process and a reasonable decision. Now, there are an awful lot of clients of ours where disciplinary issues are actually incredibly rare, which is great. But what it does mean is that you can train all of your managers, but if training is not put to use quickly, then they can forget quite a lot of that. So if that's the case in your environment, then do insist that any manager takes advice either from a nominated person or from an external advisor, before they even consider embarking on any formal disciplinary action. And do take advice early on. Don't leave a problem because of fear of repercussions of managing it, because this can also work against you. It's known as a plateau of tolerance, and basically the question is, if you've put up with this for years and years and years, then what's the problem now? That's hard to overcome. And a fear or a reluctance to address any issues because of somebody's race or religion, when in fact the issues are not related in any way to that, can result in other problems of inconsistent treatment and unfairness. So last straw syndrome is very, very common in small businesses. Don't delay action until you get to this point. And avoid emotion. The seriousness of any disciplinary situation will influence the level at which you commence. But before you jump in, step back, take a deep breath, make sure you're approaching it objectively, especially if an employee has done something which has upset you personally or another member of the team. Try and see things from all viewpoints, because then you're less likely to miss something vital. And one main cause for losing at tribunal is insufficient investigation. So investigate thoroughly before you actually end up facing a tribunal claim. And even when an employee has insufficient service to bring an unfair dismissal claim, or where your case seems clear-cut, we would still recommend that you offer the right of appeal against a dismissal, and that it's to somebody not involved in the initial decision. Now, you might not want to prolong the process, and you may actually feel that you really don't want to waste even more time on an unsatisfactory employee, but we would argue that it's far better to do this than to lose a tribunal case for not having followed a fair procedure. And offering the right of appeal does give you the opportunity to learn of any weaknesses in your case at an internal forum rather than in a public arena. And it gives you the opportunity to cover off again any additional points that are raised, or anything that may not have been covered satisfactorily the first time round. And it may simply result in the employee feeling less aggrieved, because sometimes they actually just need to feel that they've had a fair hearing. So do think about offering an appeal every time, and do use that as an opportunity to put things right. This will either reduce the risk of a claim, or at least it will give you a good defence and a better chance of settling the claim at a lower amount than if you ignore an employee's protests. Now, clearly you don't want to spend all of your life listening to a never-ending list of moans and groans, but it is a good idea to encourage the use of your grievance procedure for serious issues so that you can actually rectify these. But again, try and resolve them informally first before resorting to the grievance procedure, if you can. But ensure your employees are aware of the procedure and that they are encouraged to air any concerns and to know that these will be dealt with fairly, because that is a much better way of knowing what's really going on in your business and taking action where necessary. And again, it's better to handle these things internally rather than at tribunal. And if you have any other means of group feedback, such as a committee or a regular survey, then do use these mechanisms as a way of identifying any issues at an early stage before you're facing claims. What you can't afford to do is to ignore any allegations of bullying and harassment. These situations are never easy, and they're also very difficult to prove because very often it's one person's word against another. But as an employer, you have liability for the safety and well-being of your employees, and you're liable for the behaviour of anyone who bullies or harasses them if this is linked to the employment. So if you want to avoid claims, you need to take prompt action to resolve these sorts of issues. So always investigate fully if you hear of any concerns regarding bullying and harassment. Don't turn a blind eye to rumours. Trust your gut feeling, because if you feel uncomfortable, then the chances are that something is wrong. And take action really early on to nip any problems such as unwanted banter or sexual advances or behaviour in the bud, because that can prevent much more serious problems before the working relationships break down. If an employee is subject to disciplinary action and you're in the course of your disciplinary procedure and they make an allegation of victimization or bullying or harassment, then unless the two are totally and utterly unrelated, we would recommend that you adjourn the disciplinary hearing, investigate, resolve the allegations, and then resume the disciplinary hearing. Because the delay may well be frustrating, but at least you may have removed the basis for a future claim against you. And transparency is key on all of these sort of things. Do try to resist the temptation to fudge an issue. Dressing something up to make it appear something else, in particular dismissing unsatisfactory workers on grounds of redundancy, can be a very, very risky course of action. Redundancy is because you have a lesser need for a job to be done, and it's nothing to do with the person's ability or performance. Tribunals can see through things like this very quickly. Now, sometimes it's possible to resolve an unsatisfactory situation through a redundancy route, but only where the job is genuinely no longer needed and where there can be no doubt about your selection criteria for the person who has been dismissed. So if in doubt, take advice on that one. But fudging the issue could well come back to bite you. Now, discrimination and unfair dismissal are the key things you think about when you're thinking about tribunals, but as I said earlier, they do deal with lots of other types of claims also, including ones relating to pay, and we think that there could well be more claims relating to pay. So do check at the moment that you are paying at least the minimum wage for all hours worked, and in particular the dodgy areas. And what I mean by that are things like pre-shift meetings that have to be attended, briefings before shifts start, time spent searching employees or their possessions before they're allowed to leave the premises, changing times, clocking off times, travelling time between assignments or deductions from pay. And if you have apprentices, do check their rates of pay, because this is an area that employers have got wrong in the past quite often. Now, if you have employees who regularly work overtime or they earn commission or other payments, then do take a look at your holiday pay. As I said before, employees should get normal pay when they're on holiday, at least for the first 4 weeks of their holiday each year. We don't want you running into claims for that. And do consider equal pay. If you're a smaller employer, then the chances are you won't have a formal grading system, and the gender pay reporting requirements won't apply to you, but you are not exempt from equal pay claims. So it is worth looking at your pay and ensuring that you at least have parity amongst those who are doing the same job but of different gender, and also for jobs of equal value. And bear in mind the well-known saying that employees choose to leave managers rather than companies. So if you're wanting to keep out of tribunal, then do have a think about your culture and what it is that makes employers a good employer. And this isn't always rocket science. A lot of it is a case of following your own procedures and keeping employees up to date. Good, clear line management, where managers are well trained and they're aware what to do in difficult situations, and they think before they jump. Treating staff well, so communicating to them and keeping them on board, and encouraging them to raise any concerns at an early stage so that at least you get a chance to address them or put your side of things. Thinking carefully before you take any action or making any changes, and fully considering and consulting with the relevant people before you introduce any new process or changes, and taking advice on that. And finally, ensuring that you do document everything fully, just in case you actually need to refer to those documents later on. Hopefully, dealing with problems is not quite as scary as this slide, but they may feel so at the time. So if you do have problems with existing staff and they appear to be escalating and you feel that you're unlikely to be able to resolve them, then do consider, would mediation help at all? Don't take the issue personally and be too defensive, particularly in smaller businesses. and owner-managed businesses, this is so easy to do, but it's not always best for the business. So what's going to be best for the business here? Is this a situation that you want to resolve because you want to retain the employee, or would it actually be best for the business if you parted company? And if the latter applies, then do consider a settlement agreement. That will take away the employee's right to bring a tribunal claim in the future. And don't wait until the employee has prepared their tribunal claim. Move to resolve things before both sides get entrenched. And bear in mind that if an employee is preparing paperwork for a tribunal, it's going to annoy them and wind them up even more whilst they're writing their side of events. So if you can agree a settlement at an early stage, it may be a better solution. Consider early conciliation. We've mentioned Acas already. Their services are free, but you will need to involve them before you agree any settlement with your employee. That makes good business sense, firstly, because they are experienced in settlement negotiations. So, they have expertise on this and they will advise both parties on the strength of their positions. But also, you need to involve them early because it is their policy not to be involved in settlements where there has been no conciliation role. So they don't just rubber stamp a settlement which has already been reached. So if you think that an employee is likely to make a claim and you don't want to push them into this and you don't want it to go that far, and you would prefer to reach a settlement, then you can ask for Acas's services straight away, i.e. prior to dismissal or resignation. Now, we have covered a lot of steps to try and prevent tribunal claims, but clearly we can't keep all employers out of tribunals, and even the best ones face claims from time to time. So if this does apply to you, don't panic. You will need to act quickly, but bear in mind that there are a number of opportunities to resolve the issue along the way before you even get to the hearing stage. So if you face a tribunal claim, you have a 28-day deadline from the date the employee's claim form was posted to you in which to reply to the tribunal. Now, you do need to note that deadline, because if you don't meet the deadline, then you may lose the right to defend yourself in tribunal, in which case the tribunal only hears one side of the argument before making a decision, and that is clearly not in your best interests. So put a date in your diary at least 2 days before the deadline to respond, and ensure that you do meet it. But then sit back and think, okay, let's assess the situation. Is the claimant looking for reinstatement, i.e. return to their old job, or re-engagement, a different job within your business? Or are they simply looking for a financial payoff here? If the employee wants either of the first two, then do think about it, because clearly they don't feel that the relationship has broken down irretrievably. If they are simply looking for a payoff, then you might want to consider a settlement. And in which case, how strong is your case? Is it worth defending, or should you settle? Think about using Acas's services. If your employee will agree to participate in this, then a negotiated settlement with Acas puts an end to a potential claim. But even if you can't settle, as we've said earlier, that process will give you a much clearer idea of the strength of your case anyway. And if the case seems to have little merit, or you feel that the employee isn't actually entitled to bring the case because they don't have the right service, or because they're not an employee, for example, then you can consider asking for a preliminary hearing. Now, considering a settlement can be very, very difficult, because often it's hard to step back and take an objective view, particularly if the employee has upset you, or was a difficult person to work with, or who actually has performed to a very low level over a very long time, or if you feel that the claim's got no merit and it's totally unjustified, or the employee has put things that are untrue on their form, then you might actually feel inclined to fight it come what may. But the decision shouldn't be an emotional one. Do be pragmatic about this. Should you settle or not? Consider the strength of your case. Have you followed a fair procedure? Did you follow your rules consistently? Was your decision reasonable? A lot of small employers are worried about setting precedents, and they don't want to do this, but actually sometimes it's not worth fighting a claim that you are unlikely to win, because that again may result in further claims. Think about the time and the cost taken to defend the case. We mentioned that earlier on. It's not just your time and the time of the people who appear as witnesses, but it's the time you spent diverted from other business needs. Also the cost of any legal costs if you want legal representation. Might it be worth settling earlier before you devote any more time and energy to the issue? Estimate the likely award and take advice on this. And also bear in mind the potential negative publicity, because the full judgment, which goes into considerable detail, will be available for everyone to read. So are you happy for any weaknesses in your procedures or any completely unacceptable management behaviours to be publicly available? Now, if you choose to settle, there are two ways of doing so. I'm not going to say a huge amount about this because that's a webinar in itself, yeah. But the two ways of reaching a legally binding settlement, which puts an end to the potential claim and prevents the employee from taking it further, are done either using Acas's services and coming up with what's called a COP3 agreement. Now, achieving a settlement through Acas is entirely voluntary and it's free of charge, yeah? Or via a formal settlement agreement under which the employee has to have independent legal advice before they sign the document. Either route is an acceptable route. Both of them put a lid on the claim, yeah? But you do have to bear in mind that you cannot force your employee to consider a settlement. If they want their day in court, then they may well say, I'm not prepared to settle. So whilst it's worth thinking about, you can't actually guarantee that will happen. Settlement agreements used to be mainly high-level executives, but they are more common these days as a way of putting an end to a potential claim. And settlement agreements and COT3 agreements can be reached at any stage prior to the outcome of a tribunal hearing. So from the moment that an employee contacts Acas in the first place, or even earlier, through the whole process of preparing the paperwork, going to any pre-meetings, and the actual tribunal hearing itself, you can settle at any stage prior to the outcome being decided on. Now, clearly, we do like our clients to tribunals, but if this happens, then however brilliant an employee you are and however good a working environment you have, most employers can still find some weaknesses in their policies and procedures or some reason for things going wrong. So yes, you want to put it behind you and move on, but before you do so, do hold a post-mortem and review the case and look to see what steps you can take to avoid a similar situation in the future. Now, I hope I've covered quite a lot there. We do have a little bit of time just before we run out. So, Sue, do we have any questions at the moment that are of general applicability that you'd like me to cover now?
Yes, there are one or two, if you're okay. So we've got, does giving pay in lieu of notice extend the 3-month deadline for bringing a claim?
Well, that's an interesting one, isn't it? That's a clever way of thinking about it. Yeah. Basically, no, it doesn't actually. You don't have to add the notice period onto the termination date. So the termination date is the key date for calculating the deadline for the 3 months. So the termination date would either be the date that notice expires if it's worked, yeah, or the date that termination took place if no notice was given and pay was given in lieu, yeah, or the date of termination if an early release is agreed, or the end date of a fixed term contract if not renewed. So the 3-month deadline is a pretty tight one, and tribunals do stick very, very closely to it. They can extend that 3-month deadline if they feel it's just and equitable to do so. And the sort of situations where that may well happen is if, for example, an employee is in hospital and is therefore unable to meet the deadline. But there are lots of cases of people putting their paperwork in sort of, 5 minutes to an hour after the deadline and being told that they've missed the boat.
And that leads very nicely into another question we've had about the ET3. So if they're unsure as to whether to defend a case or not and are considering settling, should they still bother to send in the ET3?
Well, If they feel that they are likely to get a very speedy settlement, yes, then I would say don't spend all of the time preparing all of your documentation, because it does take a considerable amount of work, and obviously everything has to be right, because the ET3 is the form that you then use when you actually come to the employment tribunal hearing. Yeah. But as I said earlier, if you fail to return the completed ET3 form to the tribunal to meet the deadline, you lose the right to defend yourself. So, by all means, see if you can settle if that's what you want to do early on. But if it looks like you're not going to reach a settlement in that time, then we would always advise returning the ET3 to meet the deadline, just in order to preserve that right in case your settlement falls through.
Okay, well, another one's around the press. If there's any way of restricting the press from reporting their case. Difficult one, that, isn't it?
It is, and especially now that all of the judgments are online as well. Yeah,
absolutely.
There are some rules, but they're fairly tight ones, and they are used to protect individuals, but not to protect companies. So a tribunal can issue something that's called a restricted reporting order, and that prevents the press from identifying a person who is affected by or who's making the allegations. Now, it's only used in very, very limited circumstances, and usually cases that involve allegations of sexual misconduct or discrimination, and where evidence of a very personal nature is likely to be heard. But even where that order is made, it only actually lasts until the award and any liability has been determined by the tribunal, so it's not ongoing.
And actually that also links into another question about documents with highly sensitive information. It's always a difficult one, isn't it, whether you should disclose it or not in those cases, but I don't think there's much option even there unless you redact some of the information.
No, and it's also really difficult when you know that some of that information is not working in your favour as well. Yes. There is a temptation to withhold various things. But in terms of highly sensitive information, if it's information that's really relating to the business, like trade secrets or patents or anything like that, or recipes, or, someone has done something which really relates to the actual business itself, then it is worth raising specific concerns with the tribunal in advance of disclosure. And basically, they will take the attitude that all evidence must be disclosed. But if they feel that it is sensitive, and the other circumstances where this might apply is if you have a witness who, if that information is disclosed, it could reveal the identity of a witness who has been anonymous until this stage, and the tribunal actually accepts that the safety of that person could be compromised, yeah? Or, as I said earlier, if it's a highly sensitive trade secret, then they may well allow you to disclose the document with some information redacted, and that basically is just blanked out so that it can't be read by anybody.
So can a claim be brought against anyone other than the employer?
The answer to that is actually yes. I mean, most employees are blissfully unaware that actually claims could be brought against them personally, particularly for discrimination and harassment, yeah? And the Court of Appeal also confirmed that a claim could be brought against a qualifications body. I mean, in that particular case, it was a discrimination claim. But of course, most claims in reality are brought against the employer for the simple reason that you bring a claim against the person who is most likely to be able to pay any award that is made. Employees may not have the resources to do that. You can also bring a claim against both the employer and individual employees, and in which case, or you can bring it against multiple employers, which does happen in TUPE cases, of course, and the tribunal then can apportion how much is paid by each person.
And sometimes,
but often it can be jointly and severally as well, in which case if one person doesn't pay it, you're left with the whole bill.
Yes, sometimes it's in claims where of employee status when there's an agency worker and
yes.
as well, isn't it?
Yes,
I'll bring it against both.
Yes.
So perhaps we can round up linked with our final question, which is just to give the website link for the where you can look up tribunal case and appeal case decisions.
Oh yeah. Yeah, sure. Now, actually, if you know the wording, they're quite straightforward
Good,
for
aren't
one.
they?
Not a
Yeah.
great long link. Yes. If you want to see tribunal decisions, sorry, this isn't on the slide actually, but basically it's https www.gov.uk employment-tribunal-decisions. Yeah, and you go to that page and you can filter by country, so you can just look at England and Wales, or you can look at Scotland, and you can filter by the type of claim, and you can also put in a date range, so you can say I want to look at cases on this topic that have occurred, let's say in the last 2 years. Yep. And the Employment Appeal Tribunal decisions, again, it's a similar page, employment-appeal-tribunal-decisions. So some quite nice, easy URLs for once.
Thank you.
All of the cases aren't on there, by the way. The Employment Tribunal one, the most recent ones on there, I think, are the 6th and 7th of September today. So they're not running far behind, but obviously a lot of the older cases haven't been put online. But going forwards, it's, as I understand it, I think it's all of them.
Thank you. That's all the questions we have anyway.
Okay, lovely. Right, well, glad I've exhausted those for once. If you come up with any other questions that you would like us to answer, please do email us. And we'll get back to you. And thank you very much for attending. We do found this useful and informative as well. If you want copies of the slides or a recording of the webinar, they will be available soon. And our next webinar is planned for Tuesday, the 24th of October. So do join us. We'll be sending out invitations by the usual emails at the beginning of next month. Thank you very much and hope you all have a good afternoon. Thanks for joining us. Bye-bye.